All right, ready? Let's define our terms first of all. What do we mean by a complex case? For purposes of our discussion today, and by the way, you all have a lesson plan which will essentially mirror the PowerPoint. Please take notes on there where appropriate for your own particular professional situations. You also have a textbook which we've utilized very, very liberally in this, but we put it only with New Jersey law, okay? We're not interested in national law, strictly particular things that are applicable to New Jersey.
Understand that as long as there are defense attorneys, there will always be obstacles to obtaining evidence of guilt. Right. At least you're going to try to make it seem like obstacles, but you're in the field, so you have to think more practically. There are challenges to the admissibility of relevant evidence in court, and again, that's where defense attorneys come in. And there is proof of intoxicated operation as an element of a criminal offense.
And when we talk about these three things today, which are really that give you the complexities in drunk driving cases, the obstacles to obtaining evidence of guilt in the field is normally going to be a police-oriented type of problem, and we'll talk about it from a police perspective. Challenges to the admissibility of relevant evidence in court is both a police and a lawyer problem. So we'll be talking about it from the standpoint of prosecutors, but also how police officers can kind of take steps to prevent this from happening in the first place. And I'm going to rely upon Steve for the most part on proof of intoxication as an intoxicated operation as an element of a criminal offense, such as child endangerment, aggravated assault, aggravated manslaughter, vehicular homicide, those types of things, where the intoxication element will essentially be utilized to buttress or prove beyond a reasonable doubt the reckless element. All right? All right, let's start at the beginning. Blood evidence. Now, just a quick word about blood evidence. Blood evidence, by the way, we're entering a Chun-free zone today, okay? We're not going to talk about Alcatraz. We're not going to talk about Chun. We're talking about complicated cases, all right?
Well, what am I doing here then?
Keep asking myself that. Here's the situation. One of the biggest obstacles you're going to have in terms of gathering evidence in the field deals with blood. When you have a cooperative defendant and he gives you the blood sample and things of that nature, that's really not a problem. Where it gets complicated is when the defendant doesn't want to give it to you, or you can't get it for some other reason, okay? Or there's fighting or resistance or pollution or something of that nature that comes along. So in order to discuss these obstacles that you get in blood cases, we wanted to kind of start at the beginning. And the beginning goes back to 1966 with the case of Schmerber versus California. Now, John, read this over and then we'll talk about some of the issues that are raised here.
Sure. Schmerber said, similarly, we are satisfied that the test chosen to measure petitioner's blood alcohol level was a reasonable one. Extraction of blood samples for testing is a highly effective means of determining the degree to which a person is under the influence of alcohol. Such tests are a commonplace in these days of periodic physical examination, and experience with them teaches that the quantity of blood extracted is minimal, and that for most people, the procedure involves virtually no risk, trauma, or pain. Petitioner is not one of the few who, on grounds of fear, concern for health, or religious scruple, might prefer some other means of testing, such as the breathalyzer test petitioner refused.
Now, you see right off the bat here some of the legal issues now that have carried on that we have to deal with in New Jersey. First of all, the determination by the United States Supreme Court that the extraction of blood, generally speaking, is reasonable under circumstances that they're going to expand upon a little bit more. But notice the language of the United States Supreme Court back in 1966, which is still still in play today, in the sense that if someone were to express fear, okay, because of health or religious scruple, or prefer some other means of testing, and the issue you'll get in New Jersey a lot is going to be fear of needles, all right? You'll see that coming up in the case law. This puts in play an issue where defendants can utilize this excuse, I guess is the best word I can think of, to avoid giving you the blood sample at the hospital or some other medical facility where you want to have it taken. We'll see how New Jersey treats it in a second, but I want you to see what the basis of this is when we get into the case law.
Excuse, Bob, are you a defense attorney or a prosecutor?
I'm a prosecutor in defense attorney's clothing.
Let's talk more about Schmerber. The court goes on and says, finally, the record shows that the test was performed in a reasonable manner. Petitioner's blood was taken by a physician in a hospital environment according to accepted medical practices. We are thus not presented with the serious questions which would arise if a search involving use of a medical technique, even of the most rudimentary sort, were made by other than medical personnel or in other than a medical environment. For example, if it were administered by police in the privacy of the station house. To tolerate searches under these conditions might be to invite an unjustifiable element of personal risk of infection and pain.
So you see now where the element now that comes in New Jersey, where one of the things the state's going to have to demonstrate during one of these hearings is that the blood sample was taken in a medically acceptable way in a medically acceptable environment, all right? And we'll come back to that in a few seconds because the law is in the state of flux on that issue. But that's a requirement that the state has to show to get these blood results in evidence. All right, Dino. Okay. Here is the most recent pronouncement by the New Jersey Supreme Court, which is State versus Ravoto. Now, Ravoto involved a situation where the police who were relying basically on the prior case law, which stood for the proposition that an individual that the police have reason to believe operated under the influence of alcohol, and they bring him to the hospital, you have no right to refuse to give blood, and the police can use force in order to extract that blood sample. And that was from the appellate division case called State versus Moomer, W-O-O-M-E-R. The Ravoto case involved situations where the guy, this must have been a titanic struggle at the hospital. My recollection is there were 5 or 6 police officers plus nursing personnel that held the person down, plus they used restraints to get him. Can you imagine a drunk person being violent that way? It's hard to imagine. Anyway, they extracted the blood sample, and the challenge to this was that the state was unreasonable in the amount of force that they utilized, all right? What did the Supreme Court say about this, Johnny?
With or without a warrant, the police may not use unreasonable force to perform a search or seizure of a person. The reasonableness inquiry in an excessive force case is an objective one. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them without regard to their underlying intent or motivation. More specifically, Graham instructs courts to employ a balancing test to determine whether the use of force in a given case is reasonable. The Supreme Court explained that the proper application of the balancing test requires careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight.
What I suggest you do is circle where they say including the severity of the crime at issue, because that's going to be a major factor as police officers you're going to have to utilize in determining the level of force you're going to utilize when there's resistance on a blood draw. What do they say next, Johnny?
Well, in applying those tenets, we conclude that the force used by the police to extract defendant's blood was unreasonable under the totality of the circumstances. Defendant was terrified of needles and voiced his strong objection to the procedures used on him. He shouted and flailed as the nurse drew his blood. Several persons, including the police and mechanical restraints, were used to hold defendant down.